2 years later, in a case called American Express versus Italian Colors, this is a federal antitrust litigation brought by small businesses against American Express, alleging that, I don't know how many people know this, that American Express is actually quite an expensive card for small businesses to take. They charge more. And these businesses, all of them relatively small businesses, sued American Express for antitrust violations under the Sherman Act, alleging that the swipe fees were super competitive, to use the language of the economist language. But each of the merchant cardholder agreement contracts contained an arbitration clause. And so American Express moved to compel arbitration of this class action. And also there was a class action waiver. In other words, every merchant would have to go into arbitration individually. Any individual merchant trying to arbitrate a claim against American Express, let's say your claim is worth $1,000, you'd spend orders of magnitude more than that to try to prove an antitrust violation, because you'd need to hire an expert, you need to do a lot of discovery in order to get that claim off the ground. So clearly, compelling arbitration in this case would basically kill the case, right? Nobody could actually arbitrate the claim, but that's exactly what the Supreme Court did. They compelled arbitration, and despite the argument, which I think was forcefully made in that case, that the arbitration clause prevented these merchants from vindicating their federal statutory rights.